This is Vickie Deppe, editor of the State Legislators' Article 5 Caucus newsletter. We're back with another installment in the Article 5 Primer series, Are Our Rights Secure at an Article 5 Convention? Let's find out. The last thing any of us wants to do is hand our kids and grandkids a less free America. Thoughtful people on both the left and the right have raised concerns like this. Some are concerned about the loss of our First and Second Amendment rights. Others fear that the civil rights secured by women and minorities over the last century could be walked back. How likely is that really? I'd like to explore this from two different angles. The first is that amending the Constitution requires that 3/4 of the states ratify any proposed amendment, whether it originated in Congress or at an Article 5 convention. That's the highest threshold of any political action that can be undertaken in the United States. And it's important that we're clear on this because some opponents to this process think that amendments that are proposed by the states don't have to be ratified. That's understandable, but inaccurate. This graph shows party control of the state legislatures going back to 1978. Neither party has had control of 3/4 of the state legislatures at any point for the last 40 years. If we look at 1990, that was a pretty abysmal year for Republicans. They only controlled 6 state legislatures. As bad a year as that was for them, Democrats controlled 30 states, not enough to do anything without securing the support of Republicans in at least 8 states. We see a similar situation in 2016, but the shoe's on the other foot. The point is, the likelihood that one party is going to gain control of 38 states is remote. So I think we can rely on legislators from other political perspectives to put a stop to anything dangerous. The other angle I'd like to come at this question from is the historic interplay between the states and the federal government where civil rights are concerned. Because the Jim Crow era was so egregious and the civil rights movement that brought it to an end is still part of our living memory, many Americans think that when it comes to civil rights, the federal government is good and the states are bad. It's understandable that they see it that way, but that's only part of the story. Let's take a more detailed look at the history of civil rights in the United States. It's important to remember that slavery wasn't isolated to the South. Northern states permitted it as well, but by 1804, 8 of them had outlawed the practice. A few years later, Congress passed the Act Prohibiting Importation of Slaves, which went into effect in 1808, the earliest date permitted by the Constitution. So it seems that right out of the gate, both the states and the federal government are taking action to end slavery in the U.S. What happened next? There were some noteworthy developments in the 1840s and 50s. 9 states passed sanctuary state laws. What did the federal government do? The Supreme Court almost immediately overturned Pennsylvania's law and followed it up with the infamous Dred Scott decision, which held that persons of African descent were not citizens and therefore could not access federal courts to seek justice. In 1869, Congress refused to seat the black members of Louisiana's congressional delegation, Captain James Lewis, John Willis Menard, and Captain Pinckney Benton Stewart Pinchback. Captain Pinchback would go on to become the first governor of African descent in the United States. In 1875, Congress passed the Civil Rights Act of 1875, but in 1883, the Supreme Court overturned it. Congress would not pass another civil rights law for over 75 years. This brings us to the Jim Crow era, from which most people have come to believe that the federal government played the hero opposite the states as villains. Let's see what really happened. In the 1890s, states began passing Jim Crow laws. In 1896, the Supreme Court upheld the idea of separate but equal in Plessy v. Ferguson. The Supreme Court would continue to uphold Jim Crow laws for over a half century. In 1913, President Woodrow Wilson segregated a previously unsegregated federal workforce. In 1927, the Supreme Court reaffirmed separate but equal in Lum v. Rice. In the 1940s, New York passed a human rights law at just about the same time FDR was releasing over 100,000 Japanese Americans he had imprisoned during World War II with just the stroke of a pen. Let's move on to the next slide, where things begin looking up. In 1953, Arizona desegregated Phoenix public schools. They did the same with public housing at about the same time as well. Notice that this is before Brown v. Board, which, after 60 years, finally dispensed with separate but equal. In the 1960s, Minnesota created its Department of Human Rights. Congress passed the Civil and Voting Rights Act, and the Supreme Court handed down Loving v. Virginia. Did some states abuse their power during the Jim Crow era? Absolutely. But if we take a closer look, we can see that the federal government did too. And if we zoom out and expand our view to centuries instead of decades of our history, we can see that both the states and the federal government acted in both negative and positive ways where it concerns civil rights. In the Hofstra Labor and Employment Law Journal, Stephen Andrew Smith and Adam Hansen point out that state civil rights laws are, in many states, superior to federal statutes. They describe the states as the rightful primary protector of individual rights and argue for a greater role for state Supreme Courts in the federal appeals process. So it's not federal supremacy, but federalism, the ability of the states and the federal government to check and challenge each other, that has brought us to where we are today. Are we there yet? Clearly the answer to that question is no. But until we are, American civil rights are protected, not threatened, by the state's use of their constitutional tools to challenge the federal government.